Every American taxpayer expects federal agencies to protect their private records. During this Senate Finance Committee hearing, Senator Sheldon Whitehouse challenged Treasury Secretary Scott Bessent over 400,000 leaked tax files and an unprecedented settlement.
And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all.
That answer sets the tone for the entire confrontation. Stay with this as the questioning gets more direct and the details come to light. Here is the full hearing from the start.
Thanks very much. Secretary, welcome. Have you identified any precedent in Treasury or IRS history for the agreement not to audit, investigate, or pursue any tax claims against the Trump family or businesses?
I can't identify any precedent where 400,000 tax returns, including people you just mentioned, and all of their employees were leaked in a violation of one of the most sacred duties of the IRS.
So let me cut to that then.
Senator.
The leak was by a contractor. Can you tell me what contribution is being sought by Treasury or by the IRS for the harm done by the contractor? To a certain extent, your organization and the IRS are the victim of the contractor's malfeasance or negligence. What is being pursued by way of contribution by that contractor?
Well, the ranking member chastised me for cutting the contractor's contracts off, and we have removed their contracts, their ability to do business with Treasury and the IRS.
The core legal standoff of this hearing is happening right now. You just watched Treasury Secretary Bessent explain that the contractor lost their government deals. While terminating a vendor contract removes the contractor, it leaves open the central question of whether the agency sought financial restitution for the 400,000 taxpayers whose records were exposed. Before we continue to the next clip, hit like if you think canceling the contract was enough, or comment below if taxpayers deserve full restitution. Watch what happens right now as Senator Whitehouse presses for the terms. Senator Whitehouse refuses to drop the issue. Watch closely as he turns directly to the specific terms of the settlement.
But there is no contribution into this particular case.
Again, Senator, you weren't here earlier, but I'm unable to discuss most of this because of ongoing litigation.
Yeah, I know everybody likes to say that, but the constitutional...
We like to follow the law, Senator.
And the law is that the Congress has constitutional oversight functions that do not disappear simply because there is litigation, however convenient it may be, by way of providing answers. So we have no precedent for it. No contribution is being sought from the contractor at fault. Was there any consideration to the government in return for the benefits of no audit, no investigation, no challenge or pursuit of refunds or other penalties?
Again, Senator, I'm unable to comment because of litigation. Treasury is represented by the Department of Justice in all matters. They act as our attorneys. So I would suggest that you direct your questions to Acting Attorney General Blanche.
Yeah, well, I've had a lot of times people who are before us invite me to ask my questions of somebody who's not before us, but you're the one who is before us. And I think you ought to know if there was any consideration offered or paid in return for that settlement. It's a very simple fact question. Was there or was there not consideration?
Again, there's ongoing litigation, and I suggest that you speak with the Treasury attorneys.
This hearing is reaching its most consequential point right now. Secretary Bessent told a sitting United States senator to go ask outside attorneys. That referral sidestepped an increasingly specific line of inquiry regarding public value. In contract law, consideration is the thing of value each side gives up in a settlement. If the government agreed not to audit or investigate, what specific value did the public receive in exchange? Senator Whitehouse sought a direct factual answer on that point, which Secretary Bessent declined to provide. Watch what happens next as Senator Whitehouse introduces an internal memo cited in federal court.
If this kind of behavior is okay with the chairman, I'll just pursue other questions. But, what goes around comes around in terms of dodging questions.
I believe it's very clear that witnesses of any kind cannot discuss ongoing litigation.
They can certainly discuss a fact that they are aware of. The fact that there is some litigation out there doesn't mean that a witness can't say, yeah, there was no consideration, or yes, there was consideration. Was there a defense analysis memo? It's referenced in the judge's decision in Florida. Was there a defense analysis memo prepared by the IRS? And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all. I've been a lawyer all my life. I have some idea of what is protected when you have a ongoing bit of litigation. Whether this individual has seen an official memo from within his own department is a very simple question to answer. And I think it's completely inappropriate to have this game of dodgem be pursued without any consequences. Well,
Senator Whitehouse highlighted a key legal boundary. Litigation privilege covers legal strategy, not whether an official reviewed an internal agency document. A federal judge in Florida cited this IRS defense memo in a written decision, yet the secretary declined to confirm seeing it. Watch what happens as the questioning turns to whether demonstrable legal harm was ever verified.
Well, last of all, here's another question. Was there any analysis of what harm befell President Trump from having his taxes released when every president since Nixon released their taxes and he had promised to? Did anybody analyze whether there was actually any harm at all to him in those circumstances?
So there was a crime. President's rights under 6103 of the IRS code was violated, and equally as important, 400,000 taxpayers had that right violated, including every employee of the Trump administration, the housekeepers at Doral, the greenskeepers, the cashiers.
And you're welcome to pursue all of that, but it doesn't answer the question of whether the president actually suffered harm, and you're not answering that.
Senator Whitehouse asked a direct question about documented harm, and Secretary Bessent answered by listing hotel workers. Under federal standards, a settlement waiving tax audits requires proof of actual financial injury. But instead of providing an official analysis, Bessent pointed to housekeepers and greenskeepers. That response left the core question regarding the agreement's legal foundation unaddressed. Widening the focus to include hundreds of thousands of other individuals shifts attention away from the specific legal justification required for this particular agreement. By pulling in 400,000 victims, Bessent highlighted a real issue. The contractor's leak exposed hundreds of thousands of individual taxpayers across the country. But Senator Whitehouse was asking specifically whether the primary party in this settlement suffered measurable, concrete injury beyond the statutory disclosure violation. Without documented verification of specific harm, the legal justification for the settlement remains unsubstantiated on the record. There's a reason this distinction matters so much in American law. Statutory violations and actual damages are different categories. Under Section 7431 of the Tax Code, an unlawful disclosure of tax information entitles a taxpayer to bring a civil action. But courts look at whether real, concrete harm resulted. Actual damages, such as quantifiable financial loss or specific commercial injury, are not assumed under the law. They must be clearly demonstrated. When financial practices have already been subject to extensive public reporting, establishing demonstrable, independent harm becomes a critical legal standard. Whitehouse is a former United States attorney and former Attorney General of Rhode Island. If the IRS's own defense memo concluded that demonstrable harm was minimal or unverified, the legal foundation for foreclosing standard audits and penalties becomes questionable under federal guidelines. Looking back at the very start of this testimony, Secretary Bessent made a significant admission on the record. He stated on the record that he could identify no historical precedent for this type of agreement. The Secretary of the Treasury, who oversees the IRS, who has access to the full institutional history of that agency, sat before the Senate and confirmed that no comparable agreement exists in the record. No prior administration has established a blanket agreement for the IRS to forego standard audits or tax enforcement, according to the Secretary's own testimony before the committee. Without historical precedent, the legal framework for the settlement operates outside established administrative models. While novel cases can create new standards, it also means this agreement was established without the traditional institutional benchmarks used in prior agency decisions. In standard settlement practice, especially in high-profile cases, the agency documents its legal reasoning through formal internal reviews. Because a federal judge in Florida cited this IRS defense memo in a written ruling, the document is an established part of the court record, yet the head of the agency declined to confirm whether he reviewed it. Throughout the hearing, Secretary Bessent relied on consistent procedural boundaries, citing ongoing litigation regarding the settlement terms, pointing to vendor termination regarding financial recovery, and referencing employee privacy when asked about specific legal harm. Whitehouse's warning about institutional consequences was directed at the committee's oversight standards. The hearing concluded without further interjection from committee leaders, leaving those unanswered questions on the official record. When federal hearings leave major questions unresolved on the official record, the final judgment rests with the taxpayers. Did Senator Whitehouse ask the tough questions the public deserves to hear, or did Secretary Bessent take the proper legal stance under IRS rules? Let us know what you think in the comments section. For clear, straightforward coverage of congressional hearings and government accountability, hit that like button and subscribe to the Politics Report. Thanks for tuning in.